Hello, everyone. I'm Katie Kalmehi-Eva from Sterling Sucrose Pritchard. Thank you for joining us today. We are a full-service broker-owned risk management and insurance brokerage firm serving the commercial, professional, and personal needs of clients across a range of industries. We have over 300 team members in 6 southeastern locations, and we provide unique expertise in real estate, healthcare, construction, transportation and logistics, manufacturing, technology, and other professional services. Our product offerings include all forms of commercial and personal property and casualty insurance, employee benefits, and surety bonds. We have several events and webinars each month, and we're excited about our program today. We're going to cover 4 employment practices that your company could be messing up. Todd Stanton, founder of Stanton Law, is going to talk about contractor employee distinction, overtime, the Americans with Disabilities Act and Family Medical Leave Act, and harassment in the workplace. Todd Stanton has focused on management representation and employment matters since graduating from the University of Georgia Law School in 2002. Starting with labor and employment boutique firm Fisher Phillips, he eventually moved to Powell Goldstein, where he represented some of the largest companies in the country. That means he's responded to a lot of demand letters and agency charges, conducted harassment investigations, and slogged through plenty of costly discovery and document productions, depositions, and summary judgment motions. A litigator by training, he's well versed in the slate of employment law, shorthand, and knows firsthand how much sloppy human resources practices can end up costing. All right, everyone, please welcome Todd Stanton.
Hey, everybody. I appreciate you having me. I don't do as well. I'm going to set the bar really low as we go through this. I don't do as well on the webinar presentation, so I don't get any feedback about whether the jokes I'm saying or the one-liners I throw out there are landing. So if you can send emojis or send commentary over to Katie, she's going to be patrolling those questions and bringing them to me and let me know if I'm stepping on any toes, which quite honestly, I kind of hope I do a little bit. It keeps things lively. I appreciate being here. I appreciate Sterling having me here. They are our broker for our property and casualty and for I think our workers' comp and everything else. And we've enjoyed getting to know them. We work with Knox and with Brett on this stuff. And so if you are out there looking for a quality broker, they're certainly should be the top of your list. So what we're going to cover today is one of my favorite decks to do. It goes hand in hand with another one. We talk about 27 employment law axioms. I graduated from University of Georgia Law School in 2002. And all I've ever done is management representation and employment law issues. Now, Stanton Law has broadened out from that. We have a transactional group. We have a commercial litigation group. We have an ERISA attorney. And so we're a full-size business firm. I'm not intellectually curious. I like staying in my lane. I like doing what I do and doing it, I think, fairly well. And in that 20 plus years that we've been doing this, there are certain things that are just true. And those go into the 27 employment law axioms. It is the same fact pattern almost over and over again that if we learn to recognize these things, we're going to stay out of a lot more trouble than we would be if we're continuing to think we're unique. And then coming out of that 27 employment law practices, we've come up with this deck to reduce it to the 4 things that keep our employment law group the busiest. These are issues that when I say we deal with these daily, I mean we deal with these daily. New clients coming in with virtually the exact same problem that the clients came in with yesterday. And one of the benefits of doing presentations like this is to get the word out there to folks who are probably screwing it up, to try and get out ahead of this before they get a demand letter from Morgan & Morgan for the people, or an EEOC charge, or God forbid, a lawsuit that's going to end up setting them back 6 figures in order to prove themselves right. So I hope this is interactive. I hope that you guys will ask the questions as you come along. I hope that you argue with me about why this is or isn't a problem in your group, quite honestly. I do have, he's off camera, a member of our lead of our transactional group, one of our partners, David Adams, who, as we talk about these things, he's going to see, I'll step in real quick. That's David. that how he sees this with some practical application to his corporate clients moving forward. So, and if I say anything really dumb, I guess he'll correct me. So the first thing that we're going to talk about here is the Fair Labor Standards Act. So if the Fair Labor Standards Act is not on your radar as an HR professional, as a business, it needs to be. This is first for a reason here. Up until the pandemic, it was easily half of our practice, employment law practice. During COVID, obviously it dipped because there was a lot of other things that in the employment law world that were taking up our attention. But it has come back with a vengeance, and almost every demand letter we get with an HR or employment law issue also includes some sort of FLSA allegation, some sort of Fair Labor Standards Act allegation. So the slide that we have up right now really kind of highlights the importance to me of the Fair Labor Standards Act. So this picture was taken in December of 2018 in Bali. It was taken by a friend of mine who is a plaintiff's attorney. I'm not going to use her name because she's one of the good ones in the city. She's reputable and honest, but she certainly knows where her bread is buttered. This picture was taken on as she and her significant other finished touring all 7 continents in 2018. So they made it down to Australia and went over to Bali for a side trip there. That's their villa. The butler had just placed that tray with the perfectly poached eggs out on the infinity pool. This trip was one of the, I think there were 6 that she visited all 7 continents, was completely funded with Fair Labor Standards Act settlement money. The Fair Labor Standards Act is oppressive, and when it gets screwed up, and when a demand letter is written to a business, it doesn't matter that the business intended to comply. It doesn't matter that the business is a well-run shop. It doesn't matter that the person who wasn't paid properly is a complete deadbeat who should have been fired twice. None of that matters. It is a math problem. And when there is a Fair Labor Standards Act problem, which we're going to talk about in a minute, that recovery goes to the charging party, the plaintiff, the current or former employee or employees. That amount in back pay or unpaid minimum wage or overtime is doubled. So where there's a finding of liability, it's the back pay plus a like amount in liquidated damages. And then relevant to this picture, all of the charging parties, all of the plaintiffs, all of the employees, attorneys' fees are paid separately. So even in situations in which there is minimal liability, hundreds of dollars, thousands of dollars, maybe tens of thousands of dollars, an employer who doesn't know how to navigate a Fair Labor Standards Act problem instantly pays all of the plaintiff's attorney's fees in this, and that's what mounts up. So it's a very common occurrence. We just had one earlier in the spring that it was about a $400,000 legal bill because they went in and tried to fight about the Fair Labor Standards Act. Fair Labor Standards Act is so plaintiff friendly that once the client finally got to the point where they realized they couldn't win, they couldn't settle either. They had $400,000 worth of attorney's fees racked up with another group. They brought it over us. We were able to settle it very quickly, but it still cost them an absolute boatload while we're sending these plaintiffs attorneys on their around the world trips. So how do we avoid getting into that trouble? And that's what we're here to talk about. So the first one here is this notion of the contractor versus the employees. So contractors, 1099s, people who you don't pay on a W-2, they are not subject to the Fair Labor Standards Act. You can pay them a piece rate, you can pay them a day rate, you can pay them a weekly rate, you can put like a salary, pay them a project rate, you can pay them hourly. None of that matters to me, right? Contractors are completely separate and apart and not subject to the Fair Labor Standards Act. The problem is that lots of businesses that are considering contractors really should be employees. This misclassification problem is a huge issue. And it's incidentally, Georgia just passed a law that if you are misclassifying your employees as contractors, it could be, depending on the size of your organization, $750 to $1,500 per violation as a fine. So where we see this come up is they have a business has been utilizing what they consider to be contractors. The contractors go complete the job. They go to a Morgan & Morgan for the people, or the person who's in Bali at the time, and make an allegation that they should have been classified as employees. Sure enough, in most circumstances, they should have been classified as employees, and then they're entitled to the overtime. They're entitled to the hours worked in excess of 40 in a work week. That misclassification then generates Fair Labor Standards Act liability. So we get the question a lot, what makes a contractor, what makes an employee? That's a little bit beyond the scope of what we're going to talk about here today, but recognize that even when you have somebody who you genuinely believe fits whatever test it is that is applicable for a contractor, when the bell is rung and they contest that, you are going to have to argue about it for a long time. And as you're arguing about that, you're mounting up the attorney's fees on the other side. So in most instances where you come to me when you have contractors, I'm going to suggest that even if you're going to treat them as contractors, which is a different story again, I'm going to recommend that you treat them for payment purposes like you would an employee. That way, if it comes unglued, if it comes unraveled, you've at least dodged that Fair Labor Standards Act bullet as you move forward. Katie, do we have any questions about this coming through about the contractor and employee distinction for the Fair Labor Standards Act?
No questions yet.
Not yet. Good. Well, perhaps I'm doing such a good job explaining. All right, so the next one that we see is the salary versus exempt distinction. Salary does not mean, just because you pay somebody a salary, a worker a salary, does not mean that they are exempt from the Fair Labor Standards Act. Just because you pay somebody a salary does not mean that they are not entitled to overtime for hours worked in excess of 40. The Fair Labor Standards Act doesn't tell you how you have to pay somebody. It doesn't say that you could pay them or can't pay them a commission or a piece rate, hourly, or a salary, a day rate. It doesn't matter, right? What matters is whether or not they are exempt by their duties.
Ooh, can I ask a question?
David has a question.
What if it's what we all do in our industry?
Your industry standard doesn't make a damn bit of difference to this.
Damn it.
Sorry. So you see how we play off of each other. This is unrehearsed, by the way. Completely unrehearsed. So the 5 exemptions under the Fair Labor Standards Act are relatively narrow. There's a professional exemption: doctors, lawyers, architects, engineers, orthodontists, people who went to school for an extended course of study and then practiced that profession. They are exempt from the Fair Labor Standards Act. You do not have to pay lawyers overtime for hours worked in excess of 40. You do not have to pay orthodontists. You don't have to pay architects overtime for hours worked in excess of 40. They are exempt. There is an administrative exemption, which is the most commonly misapplied exemption, as it turns out, which is white collar work, office work, that is running the business. It is a person whose primary responsibility is exercising substantial discretion over matters of import to the company. So picture your chief human resources officer, picture your chief financial officer, your head of accounting. It is people who make policy, not just apply policy. It is people who are administratively running the business for other people to make widgets. It is not low-level functionary work. It is not an accounting clerk. It is not your receptionist. It is not an administrator in the ministerial sense. It is an administrator in a policy-making sense. So if you have somebody whose primary responsibility is exercising discretion over matters of import to the company, they satisfy the duties part. And if they are paid a salary of at least $700 and $600, whatever the current threshold is, $647 a week in salary, they don't have to be paid overtime for hours worked in excess of 40. Professional exemption, administrative exemption. The executive exemption is somebody whose primary responsibility is managing a recognized department of 2 or more full-time equivalents. So that is somebody who manages the grocery store. It is somebody who manages the accounting department. It is the foreman exemption. They are executives, and if they're paid that salary level of at least $647 a week, they don't have to be paid overtime in hours in excess of 40. We run into this problem a lot with the assistant managers, somebody who doesn't have the managing of the enterprise as a primary responsibility. It's only kind of secondary. They're on the bubble about whether they're exempted. If they're a bona fide executive, they are exempt from overtime. There is an outside sales exemption. Outside sales is somebody whose primary responsibility is making contracts for goods or services at the customer's place of employment. If they are an outside sales exemption, qualified for the outside sales exemption, they are not eligible for hours, overtime for hours worked in excess of 40. Where we see this problem come up is with account managers or inside sales reps. They are not qualified for the outside sales exemption. And if you have somebody in their home office or in their office making sales calls, managing accounts, they are still going to be entitled for overtime for hours worked in excess of 40, even if they're paid a commission, even if they are paid a salary, even if they're paid a day rate, even if they're paid a draw, they're going to be eligible for overtime in excess of 40. So if we start from the proposition that everybody in the United States is entitled to overtime for hours in excess of 40 in a work week, not 80 in a pay period, not 120 in a month, 40 in a work week, and then back out those exemptions, you start to see how ubiquitous the Fair Labor Standards Act is. It applies to everybody. It applies to all businesses. So where we get a ton of problems is where somebody says, I've paid them a salary, I don't have to worry about paying overtime. We don't keep an hours record of how much they've worked, and therefore we're really stuck when we get the demand letter because we can't argue about it because we don't want to send the plaintiff's attorney to battle. I hope that makes sense. It's hard to do without getting any feedback. The next one that we see really come up with Fair Labor Standards Act problems are smartphones. These things make it so easy for, even if we're adhering to good Fair Labor Standards Act processes, that we're keeping accurate records of the hours that are worked, we're paying people overtime for hours worked in excess of 40, non-exempt people overtime for hours worked in excess of 40. It is so easy for non-exempt personnel to do work when we don't know that they're doing work. So they check email at night, they check email on the weekend, they return voicemails on their way home. And if they're not recording those hours and they're not keeping it as part of their record of their hours worked, those turn into unpaid, uncompensated hours that Morgan & Morgan for the People absolutely love. We get it all the time. We get the question all the time. Well, what happens if we didn't tell them to work, or we told them not, and we actually told them not to work on that time? Fair Labor Standards Act doesn't care. If they are working during non-working hours, and whether they report it or not, some circumstances, if you're suffering or permitting work, if you should have known that they were working, if they're emailing the boss after hours, that's going to be sufficient to trigger that overtime obligation if it clicks them over into a excess of 40. Fair Labor Standards Act requires employers to keep an accurate record of the hours that are worked. If the employee is not keeping an accurate record of the hours that they work, they get to say how much they've, and if there's a dispute, what they say goes. The employer can try to refute what the employee says, but please recognize, back to the Bali picture, the whole time you're having David or me or one of the other your other attorneys argue about whether somebody worked an extra half hour, that may be for overtime purposes, that may be arguing over $25. You're paying your attorney $500 an hour, and you're paying the Morgan & Morgan for the People attorney $500 an hour. So without an accurate record of the hours that are worked, all you're going to do is spin your wheels and spend more money trying to prove what they did or didn't work. Be easier to go ahead and comply with the law and keep an accurate record of the hours that are worked. When you do keep a record of the hours that are worked, the next bullet comes up, which is cookie cutter time records. So the Fair Labor Standards Act doesn't say that you have to have a time clock. We don't have to be punching in and out. We don't have to be logging in and out of the computer. We can keep it on a handwritten record. You can keep it on a spreadsheet, however you want to do it. But where a plaintiff's counsel or the Department of Labor comes in to look at your your hours records and sees 8 to 6 or 8 to 12, 1 to 6, 8 to 12, 1 to 6, 8 to 12, 1 to 6, they know that's not an accurate record of the hours that are worked. They know somebody was just writing it down, irrespective of what they actually were working. So they will discount those records, especially where the charging party, the plaintiff in most instances, has said those aren't accurate records. My boss told me to write those down. My boss told me to keep the hours under 40 every week, even though I was out there. So that is the next problem. The automatic deductions problem comes where we are, again, trying to comply with the Fair Labor Standards Act. We may have accurate records of the hours that are worked, but lots of businesses will say, we know that our folks are taking, or especially our field employees, are taking an hour for lunch, and we don't want to pay them to eat lunch, which you don't have to, by the way. So we are going to automatically deduct an hour from every while they're out in the field, or when they finish their hours at the end of the week, we're going to go ahead and deduct an hour for each of the days of the week for lunch. In order for the deduction to be proper, that hour that you've deducted cannot have any work time in it. And so it's very easy for even field employees to say, sure, we finished the hole we were digging. We stopped for 30 minutes and ate a sandwich, and then we were back at it right afterwards. That's not the full hour that's deducted, and it turns into overtime liability. Where office employees eat at their desk while they're checking email, if there's an automatic deduction, that hour should have been a compensable hour and turns into a wage and hour problem at the end of the week because it hasn't been counted. Those are the ways that Fair Labor Standards Act problems, among the ways Fair Labor Standards Act problems creep into unsuspecting employers, and even employers who think that they're trying to comply with the Fair Labor Standards Act, even that they think they're complying with the Fair Labor Standards Act. We see these things coming down the pike. And remember that arguing about Fair Labor Standards Act problems it's a non-starter. I have a saying that in a Fair Labor Standards Act demand, the case never gets cheaper than the plaintiff's last demand. So when Morgan for the People sends us a demand letter and they want $30,000 for overtime and attorney's fees for a former employee, neither Stanton Law nor Fisher Phillips nor Mendelson nor whatever employment law firm you're going to be using is going to be able to resolve that claim for less than what that plaintiff is demanding. I'm not suggesting you roll over and settle. I'm suggesting that if you're not going to do that, we need to have something other than a financial reason to contest that demand. Maybe you don't want a parade of plaintiffs. Maybe you've got a competitive problem and you need to put your foot down on this. Who knows what it is, but it is not going to be that you are going to get out of your Fair Labor Standards Act problem for less money than what the plaintiff has demanded. Lest I be all doom and gloom, one of the most effective ways to combat Fair Labor Standards Act problems is with your employment agreements to make sure that if you are paying people a salary and you are not paying them overtime for hours worked in excess of 40, even if you are, I guess, make sure that in your employment agreements you have detailed that person's compensation, be it salary, commission, day rate, anything else, is intended to compensate them for all hours worked. We can go online, and I'll tell you why that's an effective tool. But in your employment agreements, in your compensation plans, you need to specify that the compensation is intended to compensate them for all hours worked. One other bullet that's not here that gets people into trouble is bonuses. If you're paying people a bonus and they are non-exempt, so they are going to be able to receive, they're eligible for overtime, entitled to overtime, bonuses affect the regular rate. So if you have a $10 an hour employee to whom who worked 50 hours in a week, you've paid them $500, you owe them time and a half for the hours worked in excess of 40, so you get to a $550 paycheck for that week. Right? If you pay them a bonus, you also have to factor that into their regular rate. So if you pay them $100 an hour for those, if you pay them $100 bonus for a week and in which they work 50 hours, you have to then divide that bonus over that number of hours worked to recalculate the hourly rate. So it comes out to be another 50 cents an hour. Their regular rate is $10.50 an hour, from which we calculate overtime, not 10. It's not as complicated as it sounds. I don't like doing math in front of people without a calculator, but when we can sit down and scribble that out on a piece of paper, you'll see that you're able to comply with it. It just takes the knowledge of the law to do it. So if there's no questions about the Fair Labor Standards Act, I'm going to move on to the next thing you're probably messing up. No questions yet, Katie?
No questions.
No questions. Is anybody even listening? Can you tell? Do they look asleep? I can't see anybody.
We have some people join. I can't
Okay.
see them, but we should be good.
All right. Somebody needs to ask a question just so I don't feel lonely. Besides David. I know what he's going to ask. All right. The next thing, we shifted this up, Katie. I don't think this is the one that you in the deck that we presented earlier. So the next thing that we are seeing more and more of is employment law problems coming from poor hiring and performance management practices. This one hits home because this is where I'm kind of blaming the victim, right? I was interviewing a client one time, and he was a very, very fast and forward thinker. He runs an HVAC company, for what it's worth, and he was anything but a dullard. This guy is pretty bright, and his motor runs really, really fast. And I asked him how he found technicians, how he found service advisors, how he found employees whose motor runs as fast as he does in the shop. How does he keep this going? And he looked at me like I had lobsters coming out of my ears. And he said, well, if my people's motor isn't running as fast as mine, that's a management failure. And I thought, well, that stinks. I want to blame others for our problems. I don't want to take this on. It's my fault. If my office isn't running the way I want it to, I want to blame the people who I hire. I don't want to have to look in the mirror at them. And that's really what comes up with this poor hiring and performance management problems. We as managers, as business owners, are going to have to look in the mirror and find out why our shop isn't running the way we want it to, why we're having employment law problems. And in lots of instances, it's us. So my number one axiom is that 5% of employees cause 95% of the problems. The purpose of that, there's a lot packed into that, and I'm going to get into some of it here. There is a certain minority in our population, and whether it's in my office, whether it's in your office, whether it is in the general population, whether it's in the workforce, whatever we want to say, that simply doesn't get it. Sometimes it's malevolent. Sometimes it's people who actively sabotage. It's active poor performance. It's active disengagement. It is a thief. It is somebody with a victim mentality. It is an entitlement mentality. It is a problem person, right? Other times that 5% in there is just bad luck. They're just snake bit. They really do get flat tires a lot. They really do get dead batteries a lot. Their kids get sick a lot. Their pets get sick a lot. They have lots of dead grandmothers. They have lots of reasons that they're going to not be able to do the job that you're expecting them to do. That 5% is a problem. And in my experience, 20 years of doing this, they're irredeemable. Once we figure out somebody fits into that 5%, our job as managers has to be to move them out and into another job, another opportunity, another place of business as soon as possible. That doesn't mean that we're moving them over to David's department from Todd's department. It doesn't mean that we're moving them from property and casualty at Sterling Seacrest over to workers' comp. We've got to get rid of them completely, right? Let's send them to a completely new law firm. We'll send them to a completely new brokerage. Let them deal with that 5%. That being said, in my experience, too many employers rest too much of their attention on that 5% rather than focusing on the 95% who are doing their job, collecting their paycheck, and going home. If we can take care of the 5% quickly and attend more appropriately to the 95%, we're going to be a better place to work. Where 5%ers are left to hang around, where we're not disciplining folks, where we are not counseling 5%ers, where we're not coaching them out and into their next opportunity, 95%ers see that and think, why am I busting my ass to work for somebody who doesn't appreciate me as a 95%er? I don't like working with jerks either. I'm gone. 95% people are marketable, 5% people aren't. So that 95% there is a lot. And if the sooner we recognize, as employers, we recognize 5%ers, the better off we're going to be to move them on down the line. So I covered it a little bit. 5%ers are your poor performers, to be sure. They are the people whose driveways ice over first and thaw out last, right? You'll notice that they miss the front and back side of every snow day. They don't get the memo. They lose emails. They are always in HR's department, the HR department. They know the handbook front and back. These are the people who are pains in the neck. We call them pudding sticks. The sooner we can start to identify them, the better off our business is going to be. Now, how does a 5%er slip through the cracks? Well, one way is we don't have them fill out an application. General and best employment law practice is that every position fills out an application, from the vice president all the way down to the custodian. We have them fill out that application, and we force them to fill it out completely, sign it, and date it. If I give a new employee an application and say, please fill this out completely, sign it, and date it, and return it to me, and it comes back and it is not completed, filled out completely, it's not signed and it's not dated, they've failed their first test. They've demonstrated to me that even when they need this job and they want it, they are on their best behavior and they still don't do what I asked them to do. The great bright line rule, it is a bright line rule and it may help, right? Having people fill out an application is the first way to start filtering out those 5%ers. Looking for a job history that includes 5 jobs in the last 12 months, that's going to be a problem. Looking for somebody whose availability is right now. How did they get in a spot where they need a job right now? Or if they don't need the job right now, are they leaving their last employer high and dry by telling you that they can start tomorrow? I'd submit that you're going to be the next employer that they screw over. Not complying with the Fair Credit Reporting Act, not doing a background check on your folks. Background checks are a special animal, and when you do any sort of employment history, when you do any sort of criminal background check, credit history, any of those sorts of inquiries through an agency, you need to comply with the Fair Credit Reporting Act. But not doing these background checks, not doing these reference checks, I don't believe is an option either. Now, I hear all the time where people say we try to do reference checks, but all we get is that they don't provide references. My suggestion is you ask one question, and that one question is, are they eligible for rehire at your shop? They will likely tell you no, but it's worth they'll likely tell you they can't answer that, but it's worth the question, because if you get the answer to that, you know whether this is a good hire or not. If somebody is not eligible for rehire at their last position, they know that former position knows something that you don't know yet. If they are eligible for that rehire, that's telling them that perhaps they were a decent employee and worth taking a chance on for you. The next way that poor performance management comes back to bite us is with annual performance evaluations. I don't like annual performance evaluations. I'm not familiar with many people who do, and yet somehow, and that's either supervisors or employees, mind you, but somehow in traditional American corporate culture, we've taken this one thing that everybody hates and made it the center of the employment law universe, where we keep track of, make it determinative of promotability and wages, whether you stay employed or not. There's too much emphasis on an annual employment evaluation. I'm much more a fan of the quarterly, monthly check-ins, quarterly performance management, something that is going to be more immediate, more timely, and providing better feedback for the employees and making it easier on the supervisor to coordinate. If you are going to have formalized evaluations, please make that part of manager training, and please make it part of manager comp. Please make it part of the manager's evaluations. Give them the time and the resources to do these evaluations properly, or they're going to be worthless. And they're worthless for the company and they're worthless for the employee if they're only getting them that feedback once a year. It makes an employment law lawyer's job very difficult when we're only looking at one evaluation from 6 months ago that says that everybody has met expectations. Now we're getting ready for a performance termination. And I have to help the supervisor come up with what has changed between when he rated them meeting expectations and where we're getting ready to pull the trigger to can them now. If you're going to take one thing away from this today, consider performance management on something other than on an annual basis. The last thing that we see really causing problems, and that I'm going to suggest that are a potential issue in your workforce, are antagonistic terminations. Firing people is a natural result of doing business. If you're big enough and you're around long enough, you're going to have to let people go, and it's not any fun. But where we can keep these separations lower temperature, where we can make them less antagonistic, we are more likely to have a smoother path and less likely to have a demand letter or litigation result from the separation. So what does that mean? Well, another one of my axioms is that surprised people get angry and angry people sue you. No one should be surprised when they get fired. If we're doing performance management properly, when we call that to be terminated employee into the office, they're going to know that this is probably their last gig. They're not going to be surprised by it. They may disagree, but they at least know it's coming. Mitigating, assuaging that surprise is the first thing that we can do. Set clear expectations, let people know when they're not meeting them. That's going to make a less antagonistic termination. Knowing your employees, right? Knowing that when their birthday is, knowing their anniversary, knowing that they have a child who's getting ready to graduate from high school, knowing that they have a daughter who's getting ready to get married, knowing that they're getting ready to have a grandchild, knowing that their wife is pregnant and might be having their own child. Don't fire them on those days. Don't fire them around that time. Right? If you've put up with poor performance for a long time, let the kid poor performance for an extended period of time. Let the kid graduate. Let the guy enjoy his son's wedding. Let him enjoy his daughter's graduation, and then pull the trigger later. Right? People who don't believe that they've been treated fairly, or we up that temperature by firing them on an important day, is going to make it more likely that they go see a lawyer. The same lawyer who I took that picture in Bali. I asked her one time what her most common claim was in coming into her office. Without hesitation, she said, people come in more often than not with claims that they were treated unfairly. Doesn't mean that they were treated illegally, but it means that they were treated unfairly. That lawyer doesn't get paid and doesn't get to take trips to Bali if she says, well, you were just treated unfairly, there's nothing I can do. What she does is she sits down and talks to them for 30, 45 minutes until she finds something that might be illegal. So here, by firing somebody on their son's wedding day, which is not illegal, it's probably being a jerk, but it's not illegal, that is perceived as being unfair, chases them to a plaintiff's attorney, and then you end up with a Fair Labor Standards Act claim that's going to cost you $25,000, $50,000, all because we didn't pay, perhaps all because we didn't take enough time to know our employees to keep that termination from being a little less antagonistic. One of the things that we specialize in at Stanton Law is trying to take, when you call us and say we've got to get rid of this particular employee, is walking you through those sorts of contingencies, walking you through those considerations, so that we minimize the likelihood of it blowing up later. One of the other axioms that we talk about a lot is that we can get you where you want to go, but not tomorrow by lunch. So if you've got somebody who you see on the chopping block, you know isn't a long-term fit, open up that conversation with your employment lawyer so that we can get you where you need to go without visiting a demand letter upon you. I'm moving on to the next thing you're probably messing up. If you would like to ask any questions, still nothing here.
I don't see any questions so far.
Bunch of bones. All right, next one. you are probably messing up the Americans with Disabilities Act and the Family Medical Leave Act. So the Americans with Disabilities Act kicks in for employers with more than 15 employees. It is on one level, a generic anti-discrimination statute. You cannot take adverse employment action. You can't fire somebody, demote them, suspend them, not hire them, pay them less, some sort of adverse employment action against somebody because they have a disability. A disability under the ADA is defined as a mental or physical impairment that substantially limits one or more major life activities. That's a lot of word salad. Lawyers love that sort of stuff because there's so much squishiness in there. We don't win on whether somebody's disabled or not. If somebody brings you a medical issue, it is more than likely that they're going to be covered in some form or fashion under the ADA. The ADA goes a little further, interestingly, and says not only can you not discriminate against somebody because of their disability, that employers have to provide a reasonable accommodation to allow the person with the disability to perform the essential functions of their job. So where somebody comes to you with migraine headaches and says, I can't work in the mornings because I have my migraines act up in the morning, that disability, migraine headaches, almost certainly a disability, is entitled to a reasonable accommodation. That may mean there's a work from home accommodation available for a person with migraines in the morning. It may mean that they have a dark office in the morning. It may mean or a dark workspace in the morning. It could be anything that doesn't impose an undue hardship upon the employer. We'll get to that. Coming back to that in a second. Family Medical Leave Act applies, and first of all, the minute that somebody's hired, they have ADA rights if you as an employer have more than 15 employees. Family Medical Leave Act has a little bit higher threshold. It is applicable to employers with 50 or more employees and locations with 50 or more employees within a 75-mile radius. Only employees, though, who have worked for that employer for a year, not consecutively, but for 12 months, and who have worked 1,250 hours in the past year are eligible for Family Medical Leave Act protection. Family Medical Leave Act, of all the employment laws, it's still oppressive and it's archaic and it's silly in a lot of regards. It's one of the easier ones to navigate, quite honestly, because the employer doesn't have much discretion. If an employee has a serious health condition, as defined by Family Medical Leave Act, they are entitled to up to 12 weeks of unpaid leave. It doesn't matter that it's going to pose an inconvenience for the company. It doesn't matter that it's going to pose a hardship for the company. It doesn't matter that it's a bad time of year. They are entitled to up to 12 weeks of unpaid Family Medical Leave Act. Lots of different things there. We're going to talk about a few of them, how we screw it up. If you're not sure whether you're subject to the ADA or family, that needs to be a threshold issue. That stuff needs to be in your handbook, incidentally. So again, that's another opportunity to talk to your friendly neighborhood employment lawyer or a qualified HR professional about that. If we're down at that basic level, we need to make sure we got that buttoned up. The ADA starts with that, I mentioned it earlier, the essential functions of the job. The employer has a large amount of discretion to define what a job is. And they get to decide what the essential functions of the job are. Now, it's what they really are. It's not just what is articulated, but it's the essence of the job, right? It is what you have to do in order to complete the tasks in front of you. So, for instance, one of the jobs, essential functions of a lawyer may be able to send emails, okay? Typing, though, would not be an essential function. Sending the email is the essential function. So if I have a sight-impaired lawyer or an employer with, or an employee with, I don't know, hypothetically, bandages all over his fingers, then, and can't type, I would then have an employer to create a reasonable accommodation for that disabled employee, the ability to perform the essential functions of the job, which is to send emails. Maybe that's a personal assistant. Maybe that's Dragon Speak. Maybe it's dictation, other sorts of dictation software, so that they can send those emails read those emails without having use of their fingers, without having use of their eyes. So, but if I have not put in my job description that there is sending emails as an essential function of the job, I have less ability to argue about what the actual job is. That's where the job descriptions come in. Having properly prepared job descriptions allows us lots more leeway in negotiating out what is going to be a reasonable accommodation with an employee than if we don't have those job descriptions. Okay? Common sense versus prejudice. This is another place in which we see too many employers messing this up. Employment laws in general and the Americans with Disabilities Act specifically are not designed to make your business easier to run. They are not designed to make you more profitable. They are designed to, in the case of Civil Rights Act of 1964, designed to help overcome societal racial prejudice or gender bias, right? And in the case of the ADA, it's designed to get the general population over its common sense, its common application of bias against people with disabilities, be that mental or physical, right? So what it's doing is it is forcing employers to look for ways to employ somebody who they might not immediately think is employable. We had a case in which a sandwich making franchise had a hearing impaired individual apply for a counter position to take orders. And they immediately said, we can't do this. We can't hire somebody who's deaf because we'll have a line around the door and all of these customers are not going to stand in line for this sub sandwich. They're going to go across the street to the Subway and order subs there because it goes quicker. That ended up being about a $45,000 settlement. How could that have been avoided? Well, instead of summarily saying we can't have a deaf counter employee, they could have engaged in this interactive process to say, how can we as a business hire a person who is hearing impaired for this counter position? Well, let's go back. What are the essential functions of the job? They have to be able to take the order. They have to be able to process what the customer wants and get it into their POS system. Could that be done by writing? Well, I don't know. That's going to take a long time. Could it be done with sign language? I don't know. That's going to be another expense to have the sign language interpreter there. So we could have gotten to where we might have said we're unable to perform the essential functions of the job and look for another opportunity. But instead, by summarily saying we can't do this, it ended up costing them about 45 grand, right? So the ADA, in lots of ways, abandons some common sense. And in other ways, it doesn't, right? We just have to engage in that interactive process. The lack of a process, not having the hiring processes in place or the even for current employees to bring their accommodation requests to management and then have them attended to, have them thought out. The ADA requires an interactive process. So when one of your employees comes to you and says that they might be having certain health issues, we got family over there that says they get the time off. ADA says we might need a reasonable accommodation on this. What that accommodation is an interactive process. It should be a give and take between management and the employee to figure out what is going to allow them to perform the essential functions of their job. Katie, do we have a question up there? I'm hoping the first one.
We do. How many write-ups or documentation before firing an employee?
Oh, that goes back to the poor performance management. The answer is, I don't know. I mean, what is it going to take to, how many times are you going to let that person not wear pants to the office before you fire them? That's a pretty severe violation. And I think that not wearing pants the first time might be a termination. If it's not showing up for work on time, what is fair in that situation? 1, 2, 5. The longer you let that issue go on, though, you're setting that bar differently. The 95%er who anticipates traffic, who anticipates being behind a school bus, who anticipates that it's raining, who anticipates that it's the first day of standard time instead of daylight savings time, anticipates that traffic is going to suck, is going to say, why did I go through this extra effort if the 5%er gets to show up whenever they want and keeps just getting written up, right? So I don't have an answer for how many write-ups it takes until somebody gets canned. What I will say is you get to decide that as an employer, and you can set that bar where you want to based upon the kind of shop that you want to be. That I would suggest is another screw up in an employee handbook, where we put in a progressive discipline policy where we say you're going to get a verbal warning and then a written warning and then a final warning, and then we're going to fire you. I don't like those. You need to have leeway so that if the offense is something that needs to be terminated from the beginning, go ahead and terminate it from the beginning. Good question. I would also submit to you that the person who asked that question, whether they're a business owner or if it's an HR person, without saying it's a dumb question, that indicates to me that that person has a lot to learn. And what I would suggest is that they probably need to talk to an HR person, because HR person or employment lawyer, because if those are the types of questions that they don't have their head around yet, there's lots of other things that they need to learn in the HR space. I hope I handled that diplomatically. David had another question.
I have a question. So this one comes up all the time. So we're getting rumors that, Bobby Joe has a drinking problem. Are there any ADA implications with that?
Drug and alcohol issues under the ADA are some of my favorite. For those of you who don't know, I've been in recovery for a while, so I answer this for two different perspectives. I answer it from an old drunk's perspective, which is we have to help them hit their bottom. The sooner they hit their bottom, the better off they're going to be. But from an employment law perspective, which is completely separate, it matters whether it's a kind of a race to the courthouse. Who is it that reports first? If somebody comes to you and says, I have a drinking problem and I need to go seek treatment, almost certainly that's a serious health condition that is going to qualify them for Family Medical Leave Act. If they're not eligible for the Family Medical Leave Act, it is almost certainly a disability that's going to require a reasonable accommodation, which may be unpaid time off. So yes, if somebody self-reports their drinking problem to you, you've got ADA and Family Medical Leave Act issues.
So can I ask a follow-up question?
Just let me finish.
Okay.
Yes is the answer, but hold on. The next one is, if you find out that somebody is drinking on the job, no, you don't have ADA or FAMLA implication. That was the question. So we get this question a pretty good bit. I want to fire David, and I say, why? And they say, because he's an alcoholic. And I say, well, that's probably illegal to fire him because an alcoholic. But why do you think he's an alcoholic? And they say, well, he shows up for work every morning. He smells like a fraternity house basement. His eyes are bloodshot and he can't sit in his chair straight. And I say, well, fire him for that. You're not firing him because he's an alcoholic. You're firing him because you can't have employees who smell like fraternity house basements. So in many cases, if it is the employer who discovers the drinking problem, that's different than if we have the self-report. Did I answer your question?
Yeah. What if the employee that shows up and you suspect that they're on drugs as opposed to just alcohol?
Yeah, we get this question a lot too. Drugs and alcohol, you do not have to put up with current use, active use, but nor do you have to have the smoking gun of a positive drug test. And in most instances, I don't recommend that we send people to that down to the clinic to get tested. If somebody shows up and has a tourniquet on their arm, fire them because they have a tourniquet on their arm, not because you think that they might have just shot up in the parking lot. Okay, we don't need to know that. The law protects reasonable suspicion, even if it's mistaken. These last two bullets on the back of the Family Medical Leave Act and why employers screw this up. Bosses and supervisors don't tend to understand what HR does, which is we have employment law obligations such that it is not as simple a proposition as if somebody can't work, we can fire them. Somebody who has a serious health condition, even when you can't see, a mental illness, migraines, cancer, who knows what it is entitled to these rights. They are entitled to time off. They are entitled to intermittent leave at times. Bosses need to understand that. Employment lawyers can play an important role in this by being the bad cop, by allowing the HR professional to preserve their business relationship with the with the boss, with the foreman, but explaining to the foreman, we are not holding you to the same performance standard because one member of your 5-member team is out on depression leave, right? We have to hold that position open. We can fill it temporarily, but we have to hold it open. That person has to come back, and we don't have a choice in this. We're not trying to make your life difficult. Those bosses get really irritated with that, and they want the person fired. They might start retaliating against the person for making it difficult. So that's where we see a lot of these problems come up as well, with these bosses who simply don't understand what the Family Medical Leave Act and ADA bring to bear. All right, the last one that we're going to talk about real quick in the last couple minutes, and we'll see if we have any other questions, is Me Too in all its forms. Now, we've been doing this deck for a while. Me Too has now transformed into a more colloquial, more broadly based wokeism across the board, that we are living in a completely new world when it comes to this stuff. And that my generation, I'm a 50-year-old white guy, right? We are having a very difficult time accepting what the new standard is as 20-somethings come into a workforce, right? I'm not going to go into all those examples there. You know what I'm talking about. Whether it's pronouns in bios, whether it is a different work ethic, whether it is a more progressive society, all of these things that are out there that are making it a different world for one generation than it was just, hell, 10 years ago, right? These sorts of conflicts in the workplace have to be managed, and they have to recognize, we have to recognize that there's a new kind of training that needs to be involved. The older generations, the more conservative generations, they don't have to like this stuff, but we're going to have to start living with it. And then on the other side, the more woke among us are going to have to recognize that not every slight that they feel comes from prohibited bias. So it's a two-way street with respect to this, and it's got to be handled very delicately. Certainly not something that we're going to cover right now. But if we can get to the point where businesses are at least acknowledging that we are in a new environment, it's going to limit your exposure from these employment law claims. I'm going to come in just under the wire. I didn't mean to rush through those last couple pieces, but that last part is something that we're all still feeling out. I came in under your time limit, Katie.
All right, that's great. I don't see any new questions at this time.
Well, I did a lot of talking.
Yes, you did. It was great. And thank you for doing this program for us today. I'll wait one more minute, see if we get some more questions come through.
Okay.
But our next Lunch and Learn program is on November 16th. The topic is ransomware trends and multi-factor authentication. And please feel free to send any program suggestions to me and your feedback. I'm Katie Kalmaheiva one more time. And yeah, I don't see any new questions. Would you like to wait, Todd, or just go ahead?
No, that's fine. If anybody wants a copy of this deck, I'm happy to send it out. You can, I'm happy to send it out. Different folks, just drop me an email or get with Katie.
Yep, definitely. I'll send a copy of the presentation and a link to the recording if that's okay.
You bet. Perfect.
All right. Thank you so much.
See you guys.